Tip number two is from Samir Kedekar. We've been weekly talking about this, all the crazy NTAs we're getting. For example, when someone has an H-1B and they're doing H-1B transfer, the previous H-1B employer terminates the H-1B, notifies USCIS, and then the person getting a notice to appear. I'm actually going to be interviewing Samir because he's been really the top lawyer, it seems, handling and dealing with this stuff, accumulating a lot of examples. And one of the worst examples he posted this week, we'll have in our show notes as well, is issued saying so USC is now issuing NTAs to alleged B-2 overstays. So these are people who file timely B-2 extension notices, and while it's pending, historically people can stay here while it's pending. They were issued notices to appeal in immigration court for being out of status. So technically, their tourist visa status expired. That one pending. It's a pretty disastrous situation. He also talks about some H-1B cases that went to immigration court. One judge understood the scenario and terminated the case so the person could go resume their H-1B transfer, which was approved. Another judge got a continuance for more when it wasn't really sure what's going on. So it's a pretty messed up situation. It makes it almost like we're sending either saying people maintain status, underlying status, like if they're F1 student, don't quit school, or we're pushing people to do consular processing now because the risks have been attained aren't too high still because the numbers aren't there, but it seems like it's edging up. So that's what I want to share with you to be aware. On any case you're doing, if the person doesn't have 100% status, and who knows, sometimes if they have status, they don't have the courtesy of a grace period, which was the whole point of grace period, but they're not going to be giving that more and more.